Welcome, everyone, and good afternoon. Thank you for joining us today as we celebrate the 75th anniversary of the Lanham Trademark Act of 1946. Our country has been blessed by individuals who have changed the trajectory of our nation, and Fritz Lanham was one such person. It's befitting, then, that we celebrate his achievement today. Throughout this program today, we're going to hear from national leaders, including Secretary of Commerce, Gina, Raymondo, members of Congress, Drew Hirschfeld, who is performing the functions and duties of the Undersecretary of Commerce for Intellectual Property and Director of the USPTO, and from those in the private sector whose success is so dependent on the registration of their company's immensely valuable trademarks. If we were all in person at the USPTO headquarters, as I would love for us to be today, we'd be hosting a true celebration with plenty to celebrate, eat, and drink. And we would also have a presentation of the colors of our great nation. We can't do that in person, but please join me as we take a moment to virtually honor Representative Fritz Lanham and our great nation with the playing of our national anthem. Wonderful. Our next speaker today is Gerard Rogers. Judge Rogers is the Chief Administrative Judge of the Trademark Trial and Appeal Board, the TTAB. As the TTAB's Chief Judge, he is responsible for all ongoing operations of the board as well as its strategic planning. The TTAB hears and decides a variety of trademark-specific cases. They hear appeals by trademark applicants from the decisions and final refusals of examining attorneys. The board adjudicates oppositions brought by third parties to challenge published applications. They rule on petitions to cancel existing registrations, and they determine geographic division of territories for marks involved in what are called concurrent use proceedings. Before taking on responsibility for the TTAB, Judge Rogers spent 10 years serving as one of the board's judges. And way back in 1987, Judge Rogers began his career at the USPTO as a trademark examining attorney. Quite honestly, as one who in a prior career steered an iconic brand, Judge Rogers was, to all of us, one of those rock stars who we in the trademark world listened to absolutely. I'm pleased we can all do so today. Judge Rogers?
Thank you, Commissioner Gooder, for the introduction and the opportunity to represent the Trademark Trial and Appeal Board in today's program. The TTAB, as many know us, is essentially the USPTO's trademark court, and now is as busy as it has ever been. The ever-increasing number of trial and appeal proceedings processed and decided by the board are a testament to the success of the statute that Congressman Fritz Lanham and his congressional colleagues created over many years of drafting. Congress has amended the law as needed, most significantly, in our view, in 1958, when it created the board, but has had no need to replace the act, which shows its real staying power and utility for American mark holders. The Lanham Act's drafters likely did not foresee the wide variety of words, symbols, sounds, colors, and other indicia that now represent to consumers the sources of an ever-changing array of products and services. At the TTAB, we've been fortunate to handle many cases involving such marks and raising new and interesting issues in trademark law. Everyone working at the board recognizes both the value of strong marks to businesses and the extent to which the public relies on brands when making their purchasing decisions. The parties who come before the board pursue the trademark law issues presented by their cases with appropriate vigor, and we address the issues diligently. On behalf of the board, I thank you for the opportunity to recognize the importance of the Lanham Act to all of us.
Thanks, Judge Rogers. It's now my privilege to introduce the Honorable Chuck Grassley of Iowa as he reflects on the 75th anniversary of the Lanham Act. Senator Grassley, a longtime supporter of intellectual property rights, serves as the President pro tem emeritus of the United States Senate. He also serves as the ranking member of the Senate Judiciary Committee and is co-chair of the Congressional Trademark Caucus, a group near and dear to the hearts of brand owners. Recently, Senator Grassley introduced a bipartisan resolution designating July as National Anti-Counterfeiting Consumer Education and Awareness Month. The resolution also recognizes and celebrates the 75th anniversary of the signing of the Lanham Act, which itself plays a significant role in protecting consumers from counterfeit products. Senator Grassley also recently introduced legislation to crack down on counterfeit merchandise entering the United States, and he has spoken on the Senate floor about the increased risks and the potential dangers that counterfeit merchandise poses to businesses and consumers. Trademark owners clearly have an ally in Senator Grassley, so let's now hear a few words from him.
Hello, everyone. I'm Senator Chuck Grassley of Iowa. I also happen to be ranking member of the Senate Judiciary Committee, which has jurisdiction over patents, copyrights, and trademarks. So I'm pleased to be here today to help celebrate with you the 75th anniversary of the passage of the Lanham Act with the U.S. Department of Patents and Trademark Office. The Lanham Act has been the foundation for modern trademark registration and protection in the United States for decades. The landmark law establishes remedies for brand owners suffering from trademark infringement, and very importantly, it protects consumers from dangerous counterfeit products. Not only are trademarks valuable business assets, they're absolutely critical to our nation's economies. Trademarks help a company distinguish its products and services from those of its competitors. The law allows consumers to quickly identify the origin of the product and make an informed decision on that product's authenticity, reliability, and quality based on the brand. Trademarks enable consumers to protect themselves by relying on known brands of products or services. They also help prevent consumers from confusion, deception, and mistakes in the marketplace. The Lanham Act has helped to guard the health and safety of consumers by criminalizing fake products in the marketplace. Now, during the COVID crisis, we saw many examples of fake protective gear, masks, hand sanitizers, and other consumer products. Hazardous counterfeit goods like these can severely impact consumer health and safety. Unfortunately, counterfeiters are constantly changing their tactics, including use e-commerce platforms and small package delivery through the mail to evade the efforts of law enforcement and legitimate brands to crack down on this illegal activity. Industry and law enforcement must work together to find ways to go after the scourge and address these new challenges. Many of you already know that I'm also co-chair of the Congressional Trademark Caucus, which was established to facilitate a dialogue and encourage collaboration between industry stakeholders and policymakers. Our goal in the caucus is to increase education and awareness about dangers of counterfeits and the important role trademarks play in helping to protect consumers and brand owners alike. I look forward to working with you all on that goal and others as we celebrate the Lanham Act's 75th anniversary.
Thank you, Senator Grassley. You know, I didn't know much about Fritz Lanham when I was sworn in as Commissioner for Trademarks just a little over a year ago. But the more I learned about him, the more I was thoroughly impressed. Upon his death, the Fort Worth Star-Telegram wrote that Lanham was courtly, urbane, and eloquent, and was unswervingly a man of his word. Today, for those of us involved in protecting trademarks, we are the beneficiaries of his goodwill, his persistence, and the foresight he had as our future trademark law was being crafted over the course of a decade. Since the Lanham Act passed in 1946, we have issued almost 6.3 million trademark registrations, and there are currently 2.76 million live registrations. Interestingly, 76% of those active registrations are owned by solo filers and businesses who own less than 10 trademarks. Today, trademarks are more recognized than ever before in our nation's history, and as the value of brands continues to soar, we owe special thanks to our current members of Congress for creating a new tool to help strengthen our trademark register. This, of course, is the recently enacted Trademark Modernization Act of 2020. At the USPTO, there are a little over 1,000 dedicated and passionate professionals examining trademark applications and protecting our nation's brands and businesses. They work in a system that was created by Fritz Lanham, a system that has stood the test of time. I'm sure if he were able to join us today, he'd be amazed to see how far his foresight and creation has taken us as we protect brands far and wide. To honor Representative Lanham, a short video was created to help spread the word about the anniversary and his contribution to our nation's trademark ecosystem. Please take a few minutes now to learn about this fascinating journey.
Today, 75 years after passage of the Lanham Act, our system of protecting trademarks has never been more important to the American economy. It's essential to brand owners, large and small, old and new. The revolution we are witnessing in the global economy, driven by the digital transformation of every industry, especially e-commerce, has caused the demand for new trademarks to surge to record levels. Looking back, it becomes clear that Representative Fritz Lanham was ahead of his time, anticipating the need for a national trademark ecosystem, one that today represents one of the key underpinnings of our rapidly evolving and expanding system of global commerce. The Lanham Act continues to provide protections to trademark owners and the assurance brand names provide to hundreds of millions of consumers. However, these assurances and protections are only possible if we remain vigilant in maintaining the quality and reliability of trademark registrations. On behalf of the more than 1,000 trademark professionals at the USPTO and the judges and staff working at the Trademark Trial and Appeal Board, we welcome the opportunity to work with trademark practitioners and owners to protect their valuable brands and the integrity of our trademark register. For that, we're grateful for the foresight and dedication of Fritz Lanham.
Even before a child has learned to read or write, they can begin to recognize trademarks. These familiar signs and expressions help us to identify the products and services we trust and to avoid the ones we don't. Each time we choose one brand over another, we owe thanks to those who shaped trademark law, including Fritz Lanham for his work on the Lanham Act. The father of American trademark protection, Frederick Garland Lanham, or Fritz, was born January 3, 1880, in Weatherford, Texas.
My grandfather, Fritz Lanham, was a Renaissance man. He was humble, he was loving, he was the most wonderful grandfather that you can imagine.
Lanham began practicing law in Weatherford in 1909. 10 years later, his political career began when he won a special election to Congress in Texas's 12th congressional district, taking the seat once held by his father, Samuel Willis Tucker Lanham. As the ranking member of the Committee on Patents, Trademarks, and Copyrights, Lanham saw the need for legislation that would address the nation's fragmented trademark laws.
When Fritz Lanham was first elected, there were limited protections for trademarks. It was challenging for businesses to take advantage of what protections did exist because the laws were state by state, confusing, and difficult to enforce.
With notes provided by Edward S. Rogers, a lawyer and trademark expert, Lanham spent hours developing the draft legislation that would become known as the Lanham Act.
This bill was designed to revolutionize trademark law by establishing ways to protect trademarks from infringement, unfair competition, and false advertising on a national scale as opposed to state by state.
In 1946, 8 years after it was first introduced, the Lanham Act passed both houses and was signed into law by President Harry S. Truman. After having been re-elected 13 times, Lanham retired in 1947.
When we reflect upon the lives of men who have left their imprint upon history, we never for an instant stop to inquire about their wealth, but we think rather of their sterling worth and of their works in the interest of their fellow men. Fritz Lanham.
Though the Lanham Act has been amended more than 20 times over the years, this standing federal law remains the primary protector of trademark rights in the U.S. and one of the most impactful accomplishments of Lanham's legacy. The original Lanham Act laid the foundation for trademark protection in the United States, and over the years, it has gained significant renown around the world.
It's because of this act that we have a nationwide trademark registration system, a uniform legal framework for addressing trademark protection, and a law that added teeth to the universally recognized registration symbol, the ubiquitous encircled R.
Trademarks have protected the single most valuable asset of the company, which is the brand and everything that it stands for. Trademarks protect what gives meaning to those words to our consumers. It's the trust that Mary Kay beauty consultants have in starting a Mary Kay business. It's the trust that consumers have in purchasing a Mary Kay product to know that it's going to be a quality product and an authentic product from Mary Kay.
Not only does the Lanham Act continue to protect businesses, but it also protects consumers. Every day, trademarks help us to differentiate between brands and to identify the ones we count on to deliver safe and reliable products. The United States Patent and Trademark Office receives over 750,000 trademark applications each year, and there are now more than 2.5 million marks with active certificates of registration. Because they are so readily recognized, trademarks represent an accessible way for the next generation to begin learning about intellectual property and discovering how trademark protections under the Lanham Act can help them to make their own meaningful mark on the future.
Next in our program, I would like to introduce you to Drew Hirschfeld. While Drew is currently performing the functions and duties of the Undersecretary of Commerce for Intellectual Property and the Director of the USPTO, Drew's permanent role is as the Commissioner for Patents, my counterpart on the patent side of the House. In this role, Drew is responsible for managing and directing all aspects of the patent organization. These things affect patent operations, examination policy, patent quality management, international patent cooperation, resources and planning, and budget administration. That's a full day's work. Anyhow, without further ado, I'll pass the mic to Drew to lead us into the next part of our program. Drew?
Thank you, Dave, for the very kind introduction, and a warm welcome to everyone joining us as we commemorate the National Trademark System created 75 years ago by Texas Representative Fritz Lanham. We're indebted to everyone who worked so hard organizing this event, especially the trademark staff at the USPTO, led by, of course, Commissioner Dave Gooder, the staff at the National Inventors Hall of Fame, who produced the wonderful documentary we just watched, and our government affairs team at the USPTO, who continually reinforces our strong partnership with our allies and friends on Capitol Hill. We're excited that members of the Congressional Trademark Caucus are joining us this afternoon, and we look forward to hearing real-world anecdotes from representatives from the private sector about the enduring importance and value of trademarks. Today, trademarks can seem ubiquitous. They're icons that identify our most well-known brands and products. Yet these images and marks tell a larger story of perseverance and promise. They are a testament to the creativity and vision of countless men and women, and they are a reflection of our national commitment to the protection and enforcement of their intellectual property rights. We have many good reasons to celebrate the successes of our trademark system that have shaped our society in so many positive ways, and we can be inspired by so many people who have and are dedicating their lives to continually improving our system of IP protection. Thank you for joining us this afternoon and for helping us commemorate the successes of our national trademark system and all those who have shaped and refined it. And now it's my pleasure to introduce a special guest this afternoon, Secretary Gina Raymondo. Our nation is extremely fortunate to have a Secretary of Commerce who understands the importance of intellectual property and knows what it takes to succeed as an entrepreneur. Our 40th Secretary of Commerce has personal experience in financing entrepreneurs from diverse backgrounds, supporting them, and mentoring them. Secretary Raymondo served as a two-time governor of the state of Rhode Island and was its first female governor. Her tenure was marked by accomplishments in innovation, workforce development, economic development, and education. As Secretary of Commerce, she has dedicated herself to those who invent, who create and build new products, and who start new companies. She knows the value of intellectual property and her many diverse experiences. It's my honor to welcome Secretary Raymondo.
Thank you so much, Drew. And thank you for your incredible service. You're doing a fantastic job leading USPTO at a very important time. And so I want to publicly acknowledge that and say thank you. It's wonderful for me to be here with you. Thank you for inviting me to be here as we celebrate the 75th anniversary of the Lanham Act. And thank you to Commissioner Gooder for hosting us today. Before I make other comments, I also want to express my gratitude to the trademark examining attorneys and the professional staff. You are the ones who keep this place going, and you do the work day in and day out, and I'm grateful for your expertise and your professionalism and your hard work. I also know that we've had a surge in trademark filings, which means more work for you, and I just want to say thank you for all of that hard and expert work. I particularly also want to say thank you to the judges and staff on the Trademark Trial and Appeal Board. You're doing a tremendous job ensuring fairness in what I know is a complex area of the law. And then, of course, thanks to Congressman Lanham, we have a national system that protects American innovation and positions us to lead in the 21st century. It was beautiful watching that video, and it's, you know, a long time, 75 years, and it's quite a legacy. And I think it's important that we take this moment to recognize the work and commit ourselves to maintaining a strong IP system. Protection of IP and trademarks are the foundation upon which we place trust in our brands and in our companies. And as Drew said, prior to entering public life, I was in the private sector and I was a venture capital investor. And I know how important it is to be able to trust investments in entrepreneurs and their ideas and their businesses. And today, especially post-COVID, as the economy gets back on its feet, we have to lean into innovation and commercialization and entrepreneurship. And that means a strong IP system, strong trademarks, strong protection of IP is critical to our innovation, to inventors, to commercialization, and ultimately to millions of good paying jobs. And so all of you are carrying on in an important way the legacy that Congressman Lanham started, and you're all playing a vital role in the IP ecosystem to make sure that America's IP system is a beacon for the rest of the world to see and is sets a strong foundation for the rest of our innovation upon which our innovation economy can be built, which is vital to Americans' global competitiveness. So thank you for inviting me. Thank you for your work. Thank you for your commitment to this work and to our strong IP system. And, you know, have a great session. And with that, I'll pass it back to Dave.
Thank you, Secretary Raimondo. We're grateful for your leadership as we head into what is really a brave and exciting new world for trademarks here in the US and everywhere around the world. Our next guest is the Honorable Chris Coons of Delaware, another strong advocate of intellectual property rights. Senator Coons serves on the Senate Judiciary Committee and is also a co-chair of the Congressional Trademark Caucus. Senator Coons co-sponsored the bipartisan resolution designating July as National Anti-Counterfeiting Awareness and Education Month. Prior to being elected to the Senate, Senator Coons worked in the private sector for W.L. Gore and Associates, an advanced materials manufacturing company that is near and dear to the hearts of mountaineers, skiers, and just about every form of outdoor enthusiast in the world. Senator Coons understands how important intellectual property protection is in promoting new technologies. As a member of the Judiciary Committee, the senator has fought to both strengthen and modernize our nation's IP system and seeks to find new ways to establish protections for American inventors and innovations. Please take a moment to listen to the words of Senator Coons.
Hi, I'm U.S. Senator Chris Coons from Delaware. In the 75 years since Congress passed the Lanham Act, American consumers and companies have benefited greatly from trademark protection. We all know as consumers the brands that we trust, and that's largely because the Lanham Act allows companies to build up their brand loyalty, to identify their products, and to protect themselves from being copied. This wasn't a completely new concept in 1946 when President Truman signed the Lanham Act, going all the way back to medieval times. Swordsmiths, blacksmiths put unique marks on their products, on their crafts, to show ownership and to help consumers know that they were getting the real thing. But it took hundreds of years before any type of legal action developed around trademarks. In our modern environment, think about the golden arches or the swoosh or the apple. You know that the golden arches mean McDonald's, the swoosh means Nike, and the Macintosh is Apple. These are trademark symbols that help you know you can trust products as having come from those trusted companies. And as consumers, we associate these symbols to these brands because their trademark has been protected. I'm co-chair of the Congressional Trademark Caucus and recognize maintaining strong trademarks for consumers and businesses is critical for our economy. In 2020, e-commerce sales in the U.S. reached $800 billion. So making sure rights created by the Lanham Act remain strong is imperative if we want to keep growing our e-commerce economy. In May, Senator Tillis of North Carolina and I introduced the Shop Safe Act that strengthens the Lanham Act and combats online counterfeiting. It encourages online platforms to adopt ways to keep counterfeit products off their websites so consumers' trust in the basis of brand loyalty isn't compromised. I'm glad to celebrate this moment, this 75th anniversary of the Lanham Act that helped fuel national brands. And as consumer protection from counterfeiting is at the top of our agenda, we're going to need to keep working to ensure the Lanham Act's passage isn't just celebrated today, but is continued in the years ahead as a strong foundation for our modern and vibrant economy. Thank you so much for letting me be a part of this celebration today, and I look forward to continuing to work with you to keep trademark law strong into the future.
Thank you, Senator Coons. Next, I'd like to introduce you to Jenny McDowell. Jenny is the Director of Government Relations for the International Trademark Association. In her position, she serves as INTA's liaison with federal and state policymakers and government officials and contributes to the development of INTA's position on national and global intellectual property issues. Prior to joining INTA in 2019, Jenny served as Assistant General Counsel at the USTR. There, she was the lead IP attorney for the US-Mexico-Canada Agreement and engaged with Congress and industry stakeholders on complex IP issues. Ms. McDowell also served as pro bono coordinator here at the USPTO. We also thought it'd be interesting to hear today from brand owners as well. So immediately following Jenny's words, we'll hear from the primary trademark counsel for 3 influential and iconic brands. They're going to share with you their stories about the Lanham Act and what it has meant to their brands. But now I'll turn it over to Jenny.
Hello, friends. On behalf of the International Trademark Association, it is my pleasure to join you today in celebrating the 75th anniversary of the Lanham Act. My name is Jenny McDowell, and I'm the Director of Government Relations for INTA, based right here in Washington, D.C. I would like to thank the USPTO for hosting this virtual program by shining a spotlight on the Lanham Act, which is America's main trademark law. We can take a few moments to reflect on why it remains important even after 75 years. First, just a few words about who we are and why we care so much about the Lanham Act. INTA is a global association of brand owners and professionals dedicated to supporting trademarks. Our members include nearly 6,500 organizations representing more than 34,000 individuals from 185 countries, all of whom benefit from our global trademark resources, policy and development, education and training, and international network. We speak for brand owners by working to harmonize laws and policies around the world on trademark and related intellectual property issues. Why is the Lanham Act fundamental to our members and to society at large? Well, many reasons. Let's remember the most important thing that trademarks do. They identify the source of the goods or services of one party from those of another. That's the first reason that trademarks are critically important. They help consumers know what to expect, and that instills trust and builds brand loyalty. Second, trademark-intensive industries contribute to job creation and economic growth in the United States and around the world. Trademark owners range from individual entrepreneurs to big brands. Just think about it. Brands elevate everyday items and they tell stories. They spark emotion. They have the power to inspire us, to exhilarate, and to enrich. Trademarks allow brands to communicate effectively with their customers. With that foundation, businesses will invest the resources in their brands, knowing that they have certain exclusive rights provided for by the Lanham Act. Later in this program, you're going to hear some very compelling stories from iconic brands. These INTA members include Harley Davidson, Mattel, and NBC Universal. These companies, like our other members, have invested in their brands and work hard to protect the public from counterfeits. That is the third reason the Lanham Act is important. Quite simply, counterfeiting is a growing problem that jeopardizes the health and safety of all of us. INTA is committed to building awareness, developing best practices, and working with both brand owners and enforcement authorities to combat the dangers of counterfeits. INTA is very proud to work closely with the bicameral, bipartisan Congressional Trademark Caucus on Capitol Hill to discuss all the important roles that we all play in protecting the public against dangerous counterfeits. Today, several co-chairs of the Congressional Trademark Caucus explained why the Lanham Act is important to them. INTA is very grateful for this opportunity to work with Congress and with the USPTO and to speak with you today. It is wonderful to celebrate the diamond anniversary of the Lanham Act. Thank you very much.
That sound is synonymous with NBC. It was the very first sound mark registered with the USPTO in 1950. we were pioneers in expanding trademark protection available to brand owners. We are so honored to be part of the 75th anniversary of the Lanham Act. Thank you to the office for putting on this event. I'm Monique Chang-Jo, Senior Vice President and Head of Brands and Content IP at NBC Universal. As part of my responsibilities, I lead the global trademark practice for the company. NBCU owns and operates news and entertainment television networks such as NBC, CNBC, Bravo, and Telemundo, motion picture studios including Universal Pictures and DreamWorks Animation, theme parks under Universal Parks and Resorts, and a premium streaming service, among others. We're known around the world for our franchises, including Jurassic World, Fast and Furious, Kung Fu Panda, and Despicable Me. Something for everyone. We create and license many goods and services, from toy cars to real airplanes, coffee makers to television shows, which brings me back to this. Since first debuting in 1929, the NBC chime has been heard by generations of radio and television audiences. It is amazing how a simple series of notes, a design, or just a word can bring to mind a world of experiences and memories. That is the power of a trademark. These days, everyone is familiar with our Peacock logo. It did not start out looking like this back in 1956. When we first introduced the Peacock design, it looked very different. It had 11 realistic-looking feathers in 6 different colors. The original purpose of the Peacock was to show the fact that we were broadcasting in color. NBC wanted consumers to immediately understand that it was at the forefront of innovation and technology. This is what it looked like. The Peacock design was chosen to usher in this new service. A few years later, having fulfilled the original purpose of introducing the world to color television, in 1962, the Peacock logo was updated. This time, it was more of a wheel of colors, which looked like this. The design evolved from a realistic depiction of the peacock to this original design. Then, a few years later, in 1986, the logo was updated again to the version that we would see and understand as the logo you see in the pillow. The feathers were pared down from 6 to represent the divisions of the company this time. So each of the colors, yellow was for news, orange is for sports, entertainment is red, stations purple, network blue, and productions was green. Each version of these peacocks has been an emblem of the network. In fact, over the years, NBC became known as the Peacock Network because of the fame of the logo. In 2020, when launching our streaming service, the company had a difficult task of selecting a new name. They ultimately turned to our iconic logo and named the service Peacock. However, they did not just want to update the Peacock again. They wanted to reinvent it, and this is where they landed. You will see each of the colors of the peacock represented in the spine of the new logo. Our business will continue to create and innovate. Branding and IP have always been integral to the company, and trademark protection is key to ensuring that our brands resonate with consumers. Thank you so much.
Hello, my name is Michael Moore, and I'm Associate General Counsel, Senior Director, and Global Head of Trademarks for Mattel, Inc. I'm thrilled to be with you all today. And as you may be able to tell, I'm coming to you from inside of Mattel's famous design center in El Segundo, California. On behalf of Mattel, I'd like to thank the USPTO and INTA for their generous invitation to be here today to celebrate this 75th anniversary of the Lanham Act, the foundation of modern U.S. trademark law. Here's a fun fact. Mattel just celebrated its 75th anniversary too. The history and success of Mattel and the Lanham Act run in parallel. And I have little doubt that Mattel's ability to succeed was and is in no small part due to the many benefits provided by the Lanham Act. Mattel's story starts in a small garage in Southern California, where some of the most well-known and beloved toy brands of all time came to life. Now, some 76 years later, Mattel is one of the most successful toy companies in the world and owns one of the largest catalogs of children's entertainment brands. From the Barbie trademark, registered in 1959 for the first three-dimensional fashion doll, to the Hot Wheels trademark, registered in 1968 for die-cast toy cars. Then there's He-Man and Masters of the Universe, registered in 1981 and 1982 respectively. The Fisher-Price trademark, first used in 1931 and registered in 1964. American Girl, Uno, Thomas and Friends, The Magic 8 Ball, Rock'em Sock'em, Polly Pocket, and many, many more. Mattel is indeed a company of many brands, and therefore many trademarks. And you'll often hear Mattel's current CEO, Anand Krais, say in interviews that Mattel is an IP-driven, high-performing toy company. And it's true. For Mattel's creativity, innovation, and success is represented by the power of the famous trademark rights it owns, rights made possible by the Lanham Act. Mattel values trademarks immensely to not only protect the value of its brands, but most importantly, to protect children and consumers as well. Thus, for almost a decade, Mattel was the #1 corporate trademark filer at the USPTO and is still one of the top trademark filers today. It is very difficult to imagine Mattel growing from a small company in a garage to becoming a leader in the toy industry without the Lanham Act. In fact, just try to imagine our present world and system of commerce without it. Federal trademark registrations under the Lanham Act have never been more important than they are today. Trademark registrations are the key tool to combat dangerous counterfeits, especially online. With the trademark registrations for its brands, Mattel has removed thousands of counterfeits from online marketplaces. And as a result, the online sales of some brands have increased, in the case of Uno, for example, by as much as 200%. Also, US Customs has seized millions of dollars worth of counterfeit Mattel products because of Mattel's trademark registrations. In one case, last December, more than $1 million of counterfeit Uno cards were seized in a single shipment at the border. These are just some examples of many, thanks to rights provided by the Lanham Act. We all owe a debt of gratitude to the Lanham Act, legislation that created a most efficient, effective, and powerful way to protect consumers and to register, recognize, and protect the rights of brand owners, both big and small, at a national level. I am grateful to the USPTO for all the work they've done and continue to do to realize the promise of the Lanham Act. And I thank them again for bringing us together today to celebrate. So, on behalf of Mattel, cheers to the Lanham Act. And I hope to be with you all in person to celebrate the Lanham Act again next year and for many years to come. Thank you.
When most people think of motorcycles, they usually think of Harley Davidson, and much of that is due to the recognition attached to the brand. The Harley Davidson brand is built on the company's trademarks, and those trademarks have been one of the company's most valued assets from pretty much the beginning. Harley Davidson was founded in 1903 in a 10-foot by 15-foot shed, and on the front door of that shed, the founders scrawled the words Harley-Davidson Motor Company. This was the beginning of an intentional brand. When the company's first motorcycle was produced later that year, it too had Harley-Davidson on the tank in the same way of that door. I think it's incredible to see the intentionality of the founders in not just creating a product, but the focus of ensuring there was consistent branding in how they showed up to the public. By 1910, Harley adopted its famous bar and shield logo, and had it registered in the United States Patent and Trademark Office in 1911, just 1 year later. This registration, early in the company's history, illustrates the value that Harley Davidson saw, not only in its brand, but in the benefits of federal trademark ownership, even predating the Lanham Act. Throughout the years, while the Harley Davidson brand was still very much associated with motorcycles, it has transformed into a lifestyle brand. You now see our logo on other products such as apparel, furniture, mugs, toys, and much more. The growth into these product areas has been supported by Harley Davidson's ability to not only register its trademarks in additional classes other than motorcycles, but also to stop those who wish to unfairly trade off of the name and brand that Harley Davidson has built. As a company, we have been very happy to rely on provisions within trademark laws, especially statutory damages, to not only obtain monetary and equitable relief, but also to deter other would-be infringers. The trademarks and trademark protections are what underscore the value and prestige of the Harley-Davidson brand and what will help it remain strong for many years to come.
Thanks, Jenny, Andrea, Monique, and Michael, for sharing your Lanham Act insights with us. I just love hearing brand stories, but I have loved it my whole life. Our next message comes from Congressman Ted Deutch from Florida's 22nd District. Congressman Deutch is also co-chair of the Congressional Trademark Caucus and is another vocal champion of intellectual property rights. He's been a longtime supporter of educational outreach programming offered by us here at the USPTO. Congressman Deutch serves as a senior member of the House Judiciary Subcommittee on Courts, Intellectual Property, and the Internet. Here then are a few words from Congressman Deutch.
Hi, it's Ted. Today we celebrate 75 years of protected innovation and strengthened patent laws under the Lanham Act. When Congress passed and President Truman signed into law the Lanham Act in 1946, they laid the groundwork for intellectual property protections that have allowed brands to maintain their integrity while protecting consumer confidence. As individuals and businesses work to create new ideas, their innovation deserves to be encouraged. Sadly, without the existence of a formal trademark protection system, innovation could not truly exist, and both businesses and consumers would suffer as a result. By allowing owners to seek legal protections for trademark infringement, the Lanham Act allows Americans' innovative endeavors to truly flourish. But our work is not over yet. Each day, Americans are creating new businesses and bringing their new ideas into an ever-growing market. And as they do this, we must ensure that they have a fair market that encourages businesses to grow stronger, more competitive, and more resilient. This starts by ensuring that we continue to protect their intellectual property rights. So I look forward to working with my colleagues in the 117th Congress as we ensure that creativity is supported and encouraged in a strengthened intellectual property system.
Thank you, Congressman. Now, closing out our program today is Coke Morgan Stewart. Ms. Stewart is performing the functions and duties of the Deputy Undersecretary of Commerce for Intellectual Property and Deputy Director of the USPTO. That's a long title, but it's fair to say that Coke is the go-to person in the Office of the Undersecretary, and she guides the USPTO on a wide variety of legal, policy, and operational matters. Coke's work at the USPTO has earned her 4 Special Act Awards, the most recent for her work helping guide our agency through the ups and downs of the pandemic. I now pass the mic to Coke Morgan Stewart. Coke?
Great, thank you so much, Dave. Hello to everyone who joined us this afternoon and hearing all of these wonderful presentations. It reminds me that recognizing and celebrating important events in American history, like the 1946 passage of the Lanham Act, gives us a chance to pause in our busy lives and look back at how these events have shaped our nation. I think I can speak for all of us in saying that the firsthand anecdotes on the importance of trademark protections we have heard today are powerful examples of the importance of intellectual property to our economy and our greater well-being. And thank you very much to everyone who shared your stories with us today. These examples remind us why our IP system remains the global gold standard. I know we were also touched by the engaging and thoughtful tributes by our friends in Congress and are very thankful for their continued support and efforts on behalf of America's innovators and inventors. I also would like to thank Secretary of Commerce Gina Raimondo for her remarks and for joining us this afternoon, and to thank Jennifer McDowell with INTA, Chief Administrative Judge Gerard Rogers, and also Commissioner Gooder for coordinating the event today. Thank you for everyone who worked tirelessly to make this brief commemoration such a success. While today we celebrate the establishment of the cornerstone of trademark enforcement and protection, our protection of intellectual property rights is like so much of the fabric of our communities and societies. It's always a work in progress. We at the USPTO are continuously improving and building on that foundation. The recent Trademark Modernization Act will help to ensure that we have the appropriate tools at our disposal to continue to safeguard and protect our national trademark system well into the future. Thank you again to all of you for celebrating this important milestone today and for your interest on behalf of America's visionaries, inventors, and creators. Thank you so much.